You're watching CBS News Detroit.
Welcome back. Today we're learning what you should do if you're disinherited or cut out of a will or trust with legal expert Danielle. Thank you so much for being here.
Thank you for having me.
Yeah, so this is kind of a big topic, I would imagine. Where should people start if this happens to them?
Well, the first thing is obviously don't panic. Sometimes people are worried they're cut out. The first thing you want to do is see the documents themselves.
Okay.
When it comes to a will, it's a little easier to get a copy of because once it's filed with the court, it's a public document. With a trust, it may be a little more complicated, so you may need an attorney to help you get a copy of that.
Okay, so walk me through this. If you're disinherited, does that mean you don't get anything at all?
It depends.
Okay.
So sometimes there are easy ways to challenge this, and you actually have good grounds to do that.
Okay.
A couple ways are, one, if someone wasn't competent when they signed the document, sometimes there's old age, there's illness, there's concerns. The other is something we call undue influence. So if someone was manipulated or coerced into executing documents by someone else, then that may be another reason where you can overturn the documents themselves.
And is that something you see often where people are making these decisions not in their right mind? And if you do challenge it, is there a deadline to do so?
Wow, that is a lot to answer.
It's kind of layered.
Yes, so this does happen. Obviously, one of the keys is you want to work with a good attorney drafting the documents to make sure your wishes are followed.
Okay.
And so if there's any concerns that someone is, has an illness or may have competency issues, that's when you either get a doctor's letter, do mental competency exams, things like that.
Okay.
As far as timelines, that is a really big issue because there are deadlines to challenge these things. And with a will, it really depends on whether or not the judge has admitted a will to the court. Once he or she has, it's very hard to challenge it. And for a trust, it's a little different, a little more concrete, where you have 2 years from the date that the person passed away to challenge it, unless you were given notice of it. And if you're given written notice, then you only have 6 months. So act quickly and don't wait.
Okay. And as a family, how can you make sure that your wishes are followed despite all of this?
Definitely work with a good estate planning attorney. So if you want to make sure your wishes are followed, maybe you do want to disinherit someone. Inheritance, we say, isn't a birthright. You have the right to give your money to whoever you want, however you want. So there's a couple things you can do. You perhaps want to work with an attorney. What I always do is put language in the document itself explaining why you're disinheriting someone or leaving someone less money than another individual. You can also use a no contest clause, which our law firm puts in all of our documents.
Got it.
So if someone tries to fight your wishes, they're disinherited and don't receive anything. And once again, it's just a matter of dotting your I's and crossing your T's. Do it the right way so your wishes are followed.
Yeah, so important and great information. Thank you so much.
Thank you,
for being
Lauren.
here.
Appreciate it.
Of course.